Let's start. The petitioner's case is that in the year 2012, one Mr. Deepak Gupta, director of the respondent of the complainant company, along with other executives, approached the senior executives of petitioner number 1 company and expressed eagerness to enter into a business relationship with the petitioner number 1 company for distribution, sale and marketing of their mobile phones and accessories in India under the HTC brand parent. The respondent company represented that they were one of the leading distribution companies in Kolkata, India, with a business history spanning more than 110 years. On December 01, 2012, after extensive discussions and negotiations, a business relationship was formalized by the signing of a distributor agreement herein after agreement, which became effective on December 01, 2012. Under the agreement, the respondent company agreed to act as a national distributor for petitioner number 1 company for Eastern and Northeastern regions, comprising the states of West Bengal, Odisha, Bihar, Jharkhand, Assam, and 6 other northeastern states. Clause 6.5 of the agreement defines the date on arrival within DOA products and the criteria for determining whether or not a product is a DOA unit. In clause 15.1 of the agreement, the parties clearly and unequivocally agreed that the agreement would be governed by the laws of Singapore and all disputes would be settled by binding arbitration under the auspices of the International Chamber of Commerce (ICC). During the year 2013 to 2014, the business dealings between the parties were conducted in a normal fashion, except for one notable exception. The respondent company was habitually delinquent or late in filing and claiming credit refund for the DOA units. Despite repeated reminders and warnings, the respondent company simply did not mend its ways in the timely filing of DOA claims. As a consequence of habitual delays on the part of the respondent company, the return of the DOA units to the petitioner number 1 company in Taiwan were repeatedly delayed. Mr. Manjit Singh, learned counsel for the petitioners, has submitted that the impute orders dated 22/03/2022, 25/04/2022 and 11/05/2022 being against the weight of materials of record is bad in law and liable to be quashed along with the proceedings. The learned magistrate aid in law in refusing to consider the applications for grant of exemption from personal attendance on the ground that the petitioners have to appear before him first. There is nothing in section 205 of the Code of Criminal Procedure which mandates that the petitioners must first personally appear before the learned magistrate before the prayer for exemption from personal appearance is considered. That the orders dated 22/03/2022, 25/04/2022 and 11/05/2022 issuing warrants of arrest against the petitioners is contrary to and in gross violation and disregard to the law laid down by the Honorable Supreme Court. The impute orders dated 22/03/2022, 25/04/2022 and 11/05/2022 passed by the learned trial court in complaint case number 28190 of the 2019 are also contrary to the recent judgment of the Honorable Supreme Court in the case of Puneet Dolaima versus Central Bureau of Investigation, Hyderabad (2020) 12 SCC 9695. On August 29, 2019, the petitioner number 1 company received the summons issued by the learned Metropolitan Magistrate 9th Court, Calcutta at its registered office in Taipei, Taiwan. on 07/11/2019 separate application on behalf of accused number 1 within bracket HTC Taiwan and accused number 2 within bracket HTC India, petitioner number 1 herein were filed under section 305 CRPC and for accused number 3 and 6 to 8 within bracket petitioners number 2 to 5 were filed under section 205 CRPC before the London Metropolitan Magistrate seeking exemption from personal appearance. The case was adjourned to 13/01/2020. On 13/01/2020, the complaint case with C/228/190/2019 was against listed before the London Metropolitan Magistrate when placed separate applications under section 305 CRPC and section 205 CRPC seeking exemption from personal appearance were filed on behalf of all accused persons para. In the present case, there is no case against the petitioners that they dishonestly induced the complaint to deliver any property para. There was neither any inducement nor any delivery of property as required. As such, an essential ingredient required to constitute an offence under section 420 IPC being prima facie not present, the offence alleged cannot be held to be proved against the petitioners or the accused. In the present case, there is no substance in the allegations and no material exists to prima facie make out the complicity of the appellants in incognizable offences. As such, the proceedings in this case should be quashed by exercising its inherent powers for ends of justice and to prevent the abuse of process of the court para. Accordingly, criminal revisional application being CRR 660 of 2020 with CRR 661 of 2020 with CRR 1855 of 2022 stand allowed, the proceedings being C of the 28190 of the 2019 pending before the London Metropolitan Magistrate 9th Court, Kolkata, including all orders therein is quashed, no order as to costs. All connected application stand disposed of. Interim order, if any, stands vacated. Let a copy of this judgment be sent to the London Trial Court forthwith for necessary compliance. Urgent photostat certified copy of this judgment, if applied for the supplied expeditiously after complying with all necessary legal formalities. Stop. Thank you. Jai Hind. Jai Mera Bharat. Powers for ends of justice and to prevent the abuse of process of the court para. Accordingly, criminal revisional application being CRR 660 of 2020 with CRR 661 of 2020 with CRR 1855 of 2022 stand allowed, the proceedings being C of the 28190 of the 2019 pending before the London Metropolitan Magistrate 9th Court, Kolkata, including all orders therein is quashed, no order as to costs. All connected application stand disposed of. Interim order, if any, stands vacated. Let a copy of this judgment be sent to the London Trial Court forthwith for necessary compliance. Urgent photostat certified copy of this judgment, if applied for the supplied expeditiously after complying with all necessary legal formalities. Stop. Thank you. Jai Hind. Jai Mera Bharat. The supplied expeditiously after complying with all necessary legal formalities. Stop. Thank you. Jai Hind. Jai Mera Bharat. Jai Mera Bharat.